Thank you for everybody joining us this morning for this discussion on unit extensions, the dangers and how to avoid them. I'm seeing quite a lot of people joined us already. Welcome, Judy. Welcome, Elise, my very good friend, Johan, Leonie, and then two people with very unique names, iPad and Samsung. Very welcome to you as well. I just would like to give the webinar courtesies for you to start off with. The webinar will be recorded and the link will be shared with all the participants once uploaded. Please remain on mute throughout the session. It's quite disturbing if some of the participants unmute and there's all strange noises in the background. So please just remember that. And then the purpose today is to share information. So pop your questions in the live chat. Hopefully we will have time to cover your questions. Hopefully we will answer some of them as we go along, but please make sure that we get your questions. Okay, then I just want to introduce the panel. Myself, I'm ABRIE SNYMAN. I'm the CEO of Multiprof Property Intelligence. I'm a town planner by trade, and I, over the years, have done consultation, and we are consulting in a spectrum of different areas, including town planning, architecture, valuations, property inspections, quite a bit of that. And then my passion is, of course, sectional title. We also do quite a bit of training on that. Then we have BJÖRN LAUBSCHER. He's the Managing Director of Merfin Valuation Services, a property valuations company established in 2002 already, offering professional and comprehensive insurance valuations and 10-year maintenance plans for sectional title schemes. And then we have Mike ADDISON. He's the co-owner and founding director of ADDISON, a registered financial services provider. The ADDISON team of advisors are committed to community scheme risk prevention and cover in South Africa. And then last but not least, we have Linda van der Merwe. She's an admitted attorney of the High Court with a specialization in sectional titles and homeowners associations. Having completed the LLM thesis on constitutionality of sectional title rules. Linda was a managing agent previously with a large managing agency and is now co-founder director at TWDM Consulting. So yeah, that is the people that we have to our disposal. Quite a bit of knowledge and experience between all the participants. So I would like to immediately start with the questions. The first question is, what is the definition of a section, common property, and the EUA? Now, I haven't discussed this with Zelinda, but Zelinda, can you perhaps just assist us with that question, and I can add to it, but perhaps you are the best qualified person to give the proper definition of it.
The proper definition of the section, common property, units, exclusive use areas, that what we're looking for?
Yes, yeah.
Okay. Fantastic. So very often in a sectional title scheme, one confuses what is a unit, a section, a door number, and it's important to remember that legally you own a section. The section is your residential section or commercial section or industrial section. It's either primary or utility, but that goes along with an undivided share in common property. And together the section and the undivided share in common property determined by your participation quota forms a unit. And then, of course, from an exclusive use area perspective, an exclusive use area is still in its nature common property, but it is allocated either in terms of the conduct rules, management rules, or registered to a specific section. And then, of course, common property is everything else that is owned by all the members of the body corporate in undivided shares, but is open for equal use and enjoyment. Is that sufficient?
That is more than sufficient. Thank you very much. I think that just set the scene so that all of us are on the same page. I'm not sure what the level of knowledge is of most of our participants, so it's good to just start off with the basics. Then the second question is, are unit extensions legally allowed in a sectional title scheme? And what is the correct process to follow if you would like to extend your unit? Now, I would like to start off by answering that question by just stating that it is possible to legalize extensions in sectional title, and especially in complexes. But we must remember that a typical duet house consisting of 2 units is also a sectional title. So all of this apply to complexes as well as duets. Today we'll focus more on the complexes issue. Now, it is not a straightforward process, and I think that is important to understand. There's many knowledge around that say, okay, you must just ask the trustees, and if they give you permission, you can carry on. It's unfortunately not that simple. There's at least 15 or 16 steps that needs to be taken when you want to legalize any additions and extensions. And it's important that you are aware of the full process of where to start and where it ends before you get involved in something like that. Now, the first thing I would like to stress, and that's especially for the managing agents and the trustees, whenever a request is received to give permission for any extensions, a yes or no is never a good idea. If you want to support it and you're happy that it will fit into your complex, it should always state that the trustees have in principle no objection, on condition that all town planning regulations, all building plan regulations in terms of the National Building Regulation Act, as well as all sectional title conditions are adhered to. By doing that, one prevents the typical situation where an owner that is none the wiser receive approval from the trustees and accept that that is it. He can carry on. He don't have to apply for any more according to any other rules or regulations. So I think that's the first thing. If you can take that away today and never just give a blank approval, because there's lots of information that is really required to make a decision like that, and we'll talk about that a bit later. Now, the process of legalizing will include, and it's not the full list, we need 2 hours to just go through the full process, so we'll just look at the basics. Firstly, one must determine what is the status of the area where you want to make this extension. Is it common property? Is it exclusive use? Or is it already part of your section as registered on your sectional title plans? So the first step would be to ensure that you have all the documentation required by all these different rules and regulations at hand, so that you can make an informed decision on that. Documents that one should have a look at, and that's also important and advice for the managing agents. Try and keep these documents as part of the service that you render to the complex. That includes things like a copy of the site development plan that is required in terms of the town planning scheme, the zoning basically. Then the building plans, then your sectional title plans, of course. And once you have those, it's possible to establish the addition that you want to do, how will it fit into the bigger scheme of things. Mostly, these additions are made on common property. And therefore, because common property is owned by all the co-owners as well, you need their permission. You cannot just decide you're going to build anything or add anything onto common property without getting permission. And that needs to be done at a special general meeting or a AGM, or you can get, I think, if you get 75% of the owners to approve, then you at least have their permission. So even if the trustees would give you permission, if you don't have the permission of the owners, it's not really worth much. Then, of course, you must appoint an architect or a draftsperson to make drawings of what you want to add. Only then you can really go to the trustees and ask for permission, because they need to know what you are applying for. And once that is done, and then, of course, those plans must be approved by council. All structures need building plans. It includes things like carports. In most areas, we mostly deal in Swane, so there might be small differences in different areas. Lapas, Wende houses, extensions to the unit, enclosing of balconies and patios. All of that have effect on certain of the aspects that is in the different laws and regulations. So once you have approved building plans, then you can start the construction, of course, and it must happen according to the building plans. And only after that have been done, in most cases, it is possible to ask a land surveyor to come and survey the addition that have been done. Interesting, if this was done on exclusive use area, of course, the exclusive use area must be made smaller, because you can't have a piece of exclusive use area inside your section as well. So once that is done, you need to fix that up as well. So the land surveyor will go through a process, and he needs to get approval then for the change to the sectional title plans. And with that approval, you can carry on with a conveyancer, basically, to make those changes. And eventually, the conveyancer will also make the changes to the sectional title itself, and the new area will be added to it. Let's just have a look. And then, of course, that must all be inspected by the building inspector, because eventually the end of this process is you need a certificate of occupancy for this addition that you have done. It's just a very short introduction, basically. Each of these have many steps, and I might have even left out some of it. So I don't know if any of the other, anybody else wants to add to that, but be aware that it's a long process.
ABRIE, could I just add one thing to it?
Yes, please.
Fantastic. So very often in practice, I'm asked whether or not an extension of a section or a creation of an exclusive use area is purchase or a sale of common property, and it isn't. And then, of course, along with that question goes, surely if somebody wants to extend their section onto common property or take a portion of common property to be their exclusive use, they should be paying the body corporate for it because their market value is going to increase. Therefore, everybody should be sharing in that. And I often tell my clients, you know, if you're open to compensating the body corporate in some way or another, of course you can, and that can be part of the special resolution that is needed, or the special unanimous for the exclusive use area route, but it is not in any way, shape or form a purchase or requiring a sale agreement or a purchase consideration or anything along those lines. And very often we call this compensation a deal sweetener. So in other words, we will give the body corporate X amount of money to fund whatever project is maybe required in terms of the maintenance, repair and replacement plan. And then of course, in exchange, we will get your special resolution. Of course, that often doesn't work because once one offers money, people tend to want more. But it is interesting how often that question comes up.
Thank you very much. That's valuable information and 100% correct, of course. I think just perhaps as a last word on this question, the reason why it is so important to follow the full procedure is because the levies is determined by the participation quota, and if additions are done that is supposed to be added to the participation quota and it's not done, technically the co-owners are paying some of this owner's levy for him. And obviously that is part and parcel of the responsibilities of trustees to ensure that all levies are collected in the correct way. Okay, that's quick. I think the next question, Björn, I think that's for you.
Yes, thanks, ABRIE, and good morning to everybody. In most of the complexes that are surveyed by Murfin, our valuation exposes the fact that some units have additions that don't reflect on the approved sectional plan and that no one was aware of, sometimes not even the owner. So this usually causes quite a stir with the stakeholders, and we have to explain to them that non-approved alterations and structures are deemed illegal, and that this can have a range of serious implications for the affected unit owners. So one of these implications are on the insurance side, and I think this is a question for Mike. Mike, what are the insurance implications for unit alterations, especially when they are not approved?
It's a common question, Björn, and it's something that you and I do discuss quite regularly. And the timing is quite good. So first of all, good morning, everybody. Sorry, I was a bit rude there. Good morning. See a lot of my friends online this morning with us. So nice to see you here. But to answer the question, yes, timing pretty good. We are busy with a very large claim where this has cropped up. In fact, it cropped up 2 days ago. And last night I was actually at a trustee meeting where 2 units have popped up on a valuation that Murfin has just done. So I'll refer them as my 2 examples this morning. So one of the problems you have, okay, so first of all, from an insurance point of view, it's actually quite easy to deal with because it's very simple. We ask the insurance company whether they will include that, and they usually do. So if we find an extension, we find that there's a section like last night's units. That's exactly what I'm doing. There's a section which is 112 square meters shown on the sectional plan, but in fact the one is 144 square meters because they've done an extension. Whether it was done properly and the plans were all done at this point, that's to be established and found. But it's very simple. I ask the insurance company, please note section number so-and-so has an extra 20 square meters. Will you accept that? And then they might ask a question or 2, but they would normally endorse the policy, including or just noting that there's an extra 20 square meters on that property. And that's prudent. I'm not going to say that if there's a damage to that illegal structure, as you put it, that the insurance won't pay. In fact, the example of the large claim, the insurance company are wanting to pay, and it's in fact the trustees that don't. So the the problem is not putting it on cover. The problem is more when it comes to claim stage that you have issues. Okay, and some of the issues that would crop up would be, for example, the trustees may be in dispute with that owner regarding that structure. In the one case this week, an owner has built a little, under his parking bay awnings structure, he's actually built a little outside toilet and little room there with bricks and ceilings and everything. And now there's been a serious flood and damages, and the loss adjuster is saying, oh, well, and the contractor is saying, okay, well, we'll include this. It's no problem. We don't mind fixing a few little ceilings in the bigger picture. But the trustees aren't happy because they're actually in dispute with this owner about the structure. You know, the trustees feel that you know, if you let one, you're paying for one. What happens if another illegal structure pops up and you won't pay for that one, etc., etc. So it's indeed, from an insurance point of view, it's more a case of, if you have got one, rather let the broker know so that he can make sure that it's included on the policy. It's rather be prudent and note it on the policy that it's there. And the second thing is, you tidy it up from a claims point of view, because when it comes to claim stage, promise you it's really messy if it hasn't been properly put on the policy. Not from an insurance point of view so much, but possibly from a dispute point of view. Okay.
Mike, can I just ask you a question, perhaps, or opinion that I received from another insurer is, and it typically refers to something like LAUBSCHER, for instance, where the policy would state that that it's, let's say, brick and tile is what the complex is built of. So the insurance risk is obviously for that. Now illegal LAUBSCHER is built, and often, and we see scary stuff where the chimney is put through the thatch, no insulation, whatever, and there's a fire. Now, typically, I understand that the LAUBSCHER might be insured for 40,000 Rand or 20,000 Rand. But now that is the cause of 3 units that is burned down. Will the insurance just say, okay, well, you paid us a premium for one in a small percentage chance of a fire, but you have allowed something that is a time bomb. Will the insurance pay those 3 units because they had insurance on the LAUBSCHER for 20,000 or 15,000 Rand?
Yeah, no, that's a tricky question, actually, ABRIE. We have had instances similar to that, where other sections are involved, where one section owner was causing the risk. The view that I have had is that the insurance company don't want to prejudice the other owners, so they have been a little bit lenient on the other owners thus far. That doesn't mean to say it will always happen, but certainly in the cases where with the insurers that we've worked with, where we've had these experiences. And I'm talking about the main ones, you know, the CIAs, the CIBs, and the Santam Real Estates that we work with quite regularly. And a case in point on that, my experience has been, a bad experience recently has been, rather be with one of the main insurers. Don't go for a cheaper quote with an insurer outside the realms of sectional title expertise, because then you do pick up more, or they call it less consideration for owners. More directly to answer your question, yes, so the chimney is a good example. If very often a person builds a braai, they get permission, and then they're supposed to build a chimney with this outside braai very near to the property. That is problematic if it's not built to specification. There are specifications as to how tall the chimney should be, how far it should be, how near it should be to the building. ABRIE, you would know those things. I don't know them off the pat. When these crop up, I've got to go and look them up because they only pop up once or twice a year for us. And we would refer them to somebody like you to get the right specifications when building it. If a fire occurs and the chimney was too short or too near or whatever the case might be, the insurance company would be fully entitled to reject the claim, because the cause was, especially if the cause was directly as a result of the defective design, perhaps is the right word.
Yeah, thank you, Mike. That answer my question, because I think it indicates that there is real danger for a complex to allow additions and extensions without proper process being followed, and a building inspector checking these things and approve building plans to make sure that you don't run insurance risk in your complex, because typically trustees are not really clued up on those type of things, and if procedures are not followed, it's very easy for a complex to end up in this type of situation where it will be to the detriment of the other owners as well eventually.
Yeah, so if I can add to that, and I mean there are a lot of implications that one can't possibly think of in that situation. But one of them, from a valuations point of view, is that the illegal structures or non-approved extensions will also have an impact on the unit's resale value, as potential buyers are either discouraged and scared off by discrepancies, or they will try to negotiate the price based on the time and effort that it will require them to rectify the unit's legal status and to get all the documents updated. And so this doesn't really only affect that one unit's market price, it can affect all the units in the complex, because once registered at the deeds office, the lowest sale price will have a negative impact on the market value of all the other units in the complex, because it sets a benchmark for prospective buyers in future. So, if you're a buyer, you will look up, maybe on a platform such as Lightstones, or just go directly to the deed office and find out what did similar properties sell for in that area or in that complex. They will see that, this is the benchmark. So you'll find that the other unit owners will be impacted when they go to market with their units. So it really is in everyone's interest to ensure that due process is followed and that all the documents are updated as soon as possible.
Thank you.
So just chip in there from my side. But Mike, another question that I've seen is, what about solar panels on the roof? So obviously a solar panel being on the roof, being an exclusive use area, how's that treated?
Okay, I'm going to go first, and then I'm going to ask Zelinda to come and pad what I'm saying. Okay, so because Zelinda and I have actually spoken quite extensively on this very issue. In fact, we're trying to put together perhaps a template way of dealing with it. Zelinda, am I right? Or is that going to take away from some of the ideas we have? But it really is a very common thing, and it's going to become more common with our recent Eskom increase. People are going to be looking at solar. In fact, they already are. The strange thing is, I don't deal with solar panels myself. It's not my business, but I certainly get the questions asked first, because it's always, what is the insurance impact? Okay, so there's to put it in boxes. I always like to put things in boxes at these webinars because of time constraints, to get a quick understanding. But there's two basic boxes from an insurance point of view of looking at these things in sectional title. I suppose in many respects it would also apply to HOAs, but sectional title more so because of what Zelinda and I have been speaking about. So in terms of a hot water solar system, that I put into box 1, and I put the other solar electricity, so where the solar panels are on the roof and then they're going to feed into batteries, I put that into box 2. Box 1 with the solar hot water installation, it might be solar panels right next to a geyser on the roof, or the geyser might be in your garage, but it sends the heat or whatever that does technically to the heater. I would consider that a hot water installation. And there you would rely on prescribed management rule 31 to some degree. So you would have some comfort there. There's still issues to look at, but it's largely dealt with with prescribed management rule 31, and Zelinda can expand on that part. The second box, which is when you're starting to put panels on the roof, and quite a few panels, because you probably need quite a few of these PVRs, I think they call them, which then feed to a whole battery bank in your garage. Or you might even need batteries on a common area that you borrow, or on your exclusive use area. And there we're starting to get into different territory, because now you've got solar panels on the roof. It's not the hot water installation, it's something else. And I've been leaning towards, perhaps an exclusive use area needs to be created for that. And there Zelinda can expand, because the problem arises, from an insurance point of view, it's quite easy. You tell the insurance company, we've got these panels on the roof. And in fact, in most cases, they're automatically insured when they go on the roof, because, you're on an all risk basis. And as far as normal perils go, it's covered. Hail or, storm damage or whatever, it would be covered. The problem arises as to who's responsible for the excess, who's responsible to maintain that. You can have all sorts of agreements between the trustees and the owner at the time, but what happens after that section sells? So from an insurance point of view, very easy to deal with. Actually, we just tell the insurance company that this is what's there, and how do they want to deal with it, and we might get a little bit more cleverer on some of the things we're doing with the solars these days. But to answer the question and correct it or pad it a little bit, Zelinda, over to you.
Thanks, Mike. It's definitely something that we've spoken about and has come up quite often. For example, the Sectional Title Facebook group has asked the question quite a lot, and it's something that we deal with almost on a daily basis as well. I know Cape Town has had its fair share of requests for water tanks and geysers and solar panels and all that fun stuff. And most new developments are obviously going that route immediately, so it's not even an issue. When we get this type of question, the first question is, where's it going to be placed? Is it going to be placed outside of your section? Is that then common property, or is it part of an exclusive use area? If it is part of an exclusive use area, then it's not an extension of a section. It's simply an improvement or building structure or alteration to an ordinary exclusive use area that needs an ordinary resolution of the members. And then as part of that ordinary resolution, reasonable conditions can be set in regard to perhaps the type of installation, the location of the installation, and of course, very importantly, the maintenance of that installation, of course, the insurance implications of that as well. If it is going to be placed on common property, obviously it needs to be placed in such a location that is not going to cause a nuisance or disturbance or unfairly utilize a portion of the common property that now cannot be utilized by anybody else. And I recently had a client say to me that in a high-rise building, an owner wanted to put solar panels on the roof to serve only their section, but it was going to be of such an extent that after a couple of requests, there would be no more roof space to serve any other section. So that's quite interesting. And the answer was that in terms of your conduct rules, you should have regulations as to any type of installation, be it solar panels. There was a question about inverters, generators, water tanks, any type of installation that one can think about. And the regulations and your conduct rules need to set out whether or not it is allowed, where it can be installed, if it is going to be installed in certain locations, how it needs to be installed, sometimes even relating to the size or the make or the type of installation, of course, and then very importantly, who is going to be responsible for the maintenance, repair and remedial work of that installation. If you're going to install it on common property without any approvals or without any rule allowing you to do that, and of course, without it being an exclusive use area, then the body corporate becomes responsible for that. And that's very unfair. And of course, a very costly exercise. So the idea of allowing an owner to put this type of installation up on the common property and then creating an exclusive use area right over it is probably the most comprehensive or protective measure the body corporate can follow. But if it doesn't do that, it has to be regulated in terms of the rules. Otherwise, stay away.
Okay, yeah, no, thanks, Zelinda. Yeah, and I suppose that also applies to any other EUA installation, be it a swimming pool or a LAPA or a BRIE area. Yeah, they all need to be treated with the same procedures. So yeah, no, that brings me to the next question. So must all body corporate members consent to a unit owner wanting to encroach on exclusive use area? And I've heard there ABRIE said something about 75%. You know, who gets involved, and you know, when do owners or trustees say yes, and when can they say no to such a request?
Okay. If just to go back to the original process, basically, a lot of factors needs to be taken into account when one consider application or a request like that. One thing that we haven't touched yet is coverage, for instance. In the town planning scheme, in your annexure, there will be a maximum coverage that would be allowed in the complex, and it can be anything up from 25% to 40%. The first problem is that what trustees will have is to know what is the existing situation in your complex. And we find, especially the older complexes, so many changes have been made over the years, so many roofed areas have been added, that it is virtually impossible for trustees to make a call on something where more roofed area is requested, for instance. So what we as a company do for many complexes is what we call a complex building audit. So we will collect, see if we can find building plans. If we're lucky, we will get the approved sectional title plans, and then we will physically go out and survey each of the units. We compare the three, and we can do calculations, for instance, of the existing coverage of the property. Because it's no use trustees give permission for another carport or whatever. If that percentage have already been exceeded, the plans will never be approved. And it's also not fair, as we said just now, to give one person permission to add another carport. He might already have one, add another one, while some people have no carports, and whenever they're going to apply, all the coverage will already been used. So we recommend that complexes do an audit first, whereby they get the information of the existing as it is now, before you can even look at other requests for additions. It takes some time, but at least, especially the older complexes, then one have a clear picture of what the situation is. And from there on, one can decide, will this fit into the complex? Is it going to affect the visual appearance? Is it going to take away some of the issues, for instance, parking and stuff? Just another example that I think is important is the conversion of garages into living areas. I think there was a High Court case not long ago, and it is really complicated purely because it's not only that you use the garage. The fact is, on the site development plan that is part of the town planning requirements, that parking space is one of the minimum requirements for the to fit into the zoning. So the moment a garage is converted, the complex become illegal in the sense that they do not provide the parking requirements anymore. And now owners start parking on common property or visitors parking. So it is in most cases very problematic and should not be encouraged at all. Because once you start, it's very difficult to stop it. And the problem is, especially when people buy a unit and it was already converted, it's very difficult to convince them that it needs to be return to its original use, but that is what often needs to be done.
But I suppose the trustees or the body corporate can also set terms and conditions, you know, such as, you know, I don't know, requesting or requiring that a deposit be paid that is refundable after the unit owner has met all terms and cleaned up after the extension or renovation process, just as an example.
That's quite an interesting one. That particular High Court case, ABRIE, was a client of mine, an owner in the sectional title scheme, and she approached the community scheme ombud service because although the scheme was resort type in Mossel Bay, after a couple of years, more and more people started residing there on a permanent basis, and it became a bit of a retirement scheme at the end of the day. So one can imagine that parking that was never really a problem other than over holiday season suddenly became a big issue. And people were literally just snatching up any portion of common property anywhere, be it in front of their own units or in front of somebody else's unit, to now create additional parking because garages were converted into additional space. And the reason for the conversions were that the homes were actually quite small, and as units were sold and of course as families grew, the holiday makers and eventually the permanent residents needed more and more space to live. So, you know, it was a reasonable thought process of theirs to say, well, it's my units, I'm not using the garage, we don't need to park the car in the garage, we can put up a shade port or whatever it might be, let's go ahead and convert. But of course they didn't follow the right process, and legally it needs the written consent of every single owner. So that is, you know, that's quite a big, tall ask. And unfortunately, the owner was not successful at the community scheme ombud service, but she felt strongly enough about it that she took the adjudication order on appeal. And my colleague Simon Thompson from BBM Attorneys was the lead attorney on that. And I think it was quite a landmark judgment for sectional title in regards to change of use. And, you know, besides the municipal considerations of whether or not a garage can be a habitable space and what needs to happen to it to make it a habitable space, you know, if you're going to convert any part of your section or any section or exclusive use area to anything other than what the sectional plan say or the building plan say or the rules of the body corporate says or physically what it is, then you need the written consent of all owners. And if you can't get that, you can approach the community scheme ombud service for them to make the decision on the owner's behalf. And sometimes it's not a matter of not getting the consent because people object, it's not getting the consent because people can't be bothered to reply, which I suppose is every single managing agent's nightmare. But that was a really good one. I would recommend that everybody on this webinar definitely go and have a read through that.
Thanks.
I can add something on the insurance side regarding garages, conversions. Mr. Chair, can I carry on?
Go ahead, Mike.
Okay, so one of the issues that I see, and we all know that this is very common, and I'll go and visit a new scheme or an existing scheme, and somebody will proudly show me their conversion. Their double garage is now beautifully tiled, and it's there. In fact, the one that springs to my mind is one in Edenvale, where this beautiful double garage is. This elderly couple are so pleased and proud of their knitting room. They've got knitting machines, and this is their hobby room, and so on, embroidery. And I just feel so, you know, I looked at this and I thought, oh, can't have that. I haven't got the heart to tell them. But it's problematic because what they've done there is they've taken the doorway. Now, ABRIE would perhaps know more about this than I do, but when usually between especially a double garage, and your residential part of the section, you have a fire door, and the fire door is obviously a requirement in terms of, you know, normal fire safety, and it prevents the spread of fires that may start in the garage because of some combustible material could now spread into the house, or vice versa, and cause, you know, a bigger damage if the house fire spread into the garage. So of course an insurance company would have the right to you know, be very apprehensive when it came to a fire claim under those circumstances. In this particular case, they knocked out the door and built a beautiful arch, double arch for that matter. So, you know, I mean, we could fix it. We tell the insurance company, look, the spread of fire risk is higher now. Are you happy? Yes, we're happy. But if I hadn't even just simply endorsed the policy like that, had a fire occurred there, there would have been a problem. So yeah, just bear that in mind. The spread of fire is one thing, but you're also what they call increasing communication when you extend. So the insurance company have given you a premium based on a certain square meterage they've looked at. We've given them a schedule of replacement values, which might say 120 square meters, but actually there's 160 square meters. So when the fire comes, you know, the insurance company would be well within their rights to say, well, you know, we're actually insuring 120 square meters, not 140 square meters. So just, you know, bear those things in mind. If there are alterations, you know, let the insurance company know, or let your broker know, so that your broker can deal with it. As long as you've got an email to the broker advising him or her on what has gone on, you know, I think pretty much the managing agent is covered. But there's a huge onus, I believe, on the portfolio manager to look out for these things. Zelinda and I have, about a year ago, Zelinda, you might remember, we looked at, that's where I learned the block plan versus, you know, for many years I've called the sectional plan the layout of the place, the footprint, but because Zelinda has corrected me, so I learned last year that it's called a block plan. And I always look at the block plan. It's a very important look down on the place. And when we look, when Murphin have just gone out to do a valuation, and they've I look at the valuation, and then I try and take a picture of, I try and bring up onto my screen the block plan, and then I look at a Google map to try and see where these things are, because and see, you know, Murphin identifies some of them, you know, they can't get to those areas, and it puts a huge, I think, responsibility on the portfolio manager. You know, trustees and owners don't understand these things, and you know, the portfolio manager is probably, Zelinda may or may not agree with me, but I believe the PM has got almost a responsibility to, as their sort of paralegal advisor, to, you know, let them know, look, you know, there's something going on here. We need to sort these things out, and definitely bring it to the insurance company's attention. End of story.
Okay. So I think we're slowly running out of time here, but I want to throw in one last question, and I see there are a lot of questions on the chat, and we won't let them go unanswered. We will actually, when we send out an email with the link to the recording of this discussion, we'll try and also just go through all those questions and see if we can answer as many as possible of them, so that nobody misses out. But one last quick one, and I think we can get a quick answer from Zelinda on this one. Who's responsible for, or who pays for the registration and correction of the documents and everything if a previous owner made additions and alterations without approval? So the next owner moves in and finds that he's sitting with this problem. Who's going to be liable for rectifying that problem and getting the sectional title plans up to date again?
So that's the answer that makes me public enemy number one, unfortunately, and that is whoever is the registered owner at that particular point in time that discovers the mishap. So I've had one instance of a body corporate in Cape Town where there's about 140 units, and over the 140 units, more than 90% of the units have had various types of building contraventions or requirements for creation of exclusive use areas or extensions of sections. And in that particular scheme, because of the large number of owners that were affected, obviously not necessarily owners that undertook the work, but successors, the body corporates actually, as part of the special resolution, although, you know, basically all the owners were part of that, they decided that the body corporates would pay for those expenses, simply because it would be better for the body corporate to orchestrate the entire project at once, appoint one architect or land surveyor, you know, make one application to the Surveyor General, make one application via one conveyancer, and then of course there was a massive savings in costs. I have never seen it happen anywhere else other than this, and it took like 3 years to be able to formalize at the end of the day. But generally speaking, it is whoever is the owner at the time that the contravention needs to be rectified, that is the owner that needs to pay for it. And very often, if you haven't been advised by the seller of this, in my opinion, material defect, then obviously you could have a claim against the seller and potentially even the estate agent for not disclosing that in terms of the consumer protection legislation. But it is most certainly not a body corporate responsibility unless, you know, you can prove that every single unit owner is affected one way or another, and there's going to be this massive project that is going to be undertaken.
Yeah, so I think we can all agree that you know, there's a lot to be thought about before you think about your extensions, and you know, it's not just about what am I going to build and what's it going to look like, but the whole process that goes into it. And I think it would be prudent for anyone to first consult with or get legal advice from someone like Zelinda, speak to their brokers, someone like Mike, before they, you know, go into the whole, or jump into the whole process. And yeah, no, it's a very complicated issue. So I think unfortunately we're running out of time, and like I said, we will get to all the questions. We will send a follow-up email to everyone that participated today. Look out for that sometime next week. Give us a few days, please. And yeah, I would like to say thank you very much to Zelinda for joining our discussion, and Mike, you as well. And yes, to Multiprof ABRIE, thanks for co-hosting this. Yeah, and with that, I'd like to wish everyone a happy weekend, and yeah, see you all soon.
Mike, Björn, can I perhaps just get the last word in?
No problem.
Thank you. We just quickly went through the whole process, but from Multiprof's side, we are prepared to offer a free training session on these procedures to any of the participants today. So I think when we send out the information, we will ask who's interested, and we can present a Zoom meeting with more details and stuff for all the participants, whoever is interested.
Yeah, ABRIE, I think that's a great offer. And yeah, well, I think after this, we'll just quickly connect, and then I'll get the details from you, and then we'll put all that in the email.
Fantastic. Thank you very much for having us.
Thanks, everyone. Bye. Have a nice weekend.
Bye.